So today we're here this is a presentation about notaries without bond. So hopefully this is what all you guys came here for. Speaking to you today is going to be Robert Sumners. He's the Director of Government Filings here at the Texas Secretary of State's office. He received his undergraduate and law degrees from UT of Austin. He was in private practice for 20 years, and now he's worked with the Secretary of State for another 18 years. One of his responsibilities at the office is to supervise notary public commissioning and complaints against notaries. So he knows all kinds of different things about the notarial process, and he's here today to give you a little bit of information. So here he is.
Thank you, sir. Well, if you are here to hear about notaries without bond, that probably means that a bunch of you are already notaries without bond, and you need to know that you're a very special breed. Less than 1% of all Texas notaries are notaries without bond. And so the process that you go through and what you do when you're coming out of that commissioning is a little bit different. We're also going to talk about some things that you need to, because you are a notary without bond, some of your rights and responsibilities are a little bit different from others. We're also going to talk about some things to keep you out of trouble. There are ways that notaries can do things and there are things that they shouldn't do. So we'll be talking about some statutory requirements and also some best practices, not only about notaries without bond, but other folks as well. We're a small enough group today, so I hope you will feel free to answer questions in the middle of this presentation, or if you have any comments you want to share with the group. We have this neat little toy that we're going to pass around to anyone that wants to try it out. So please feel free to stop me along the way anytime you want to do that. We would like to find out if there are any particular problems that you're having in your practice that perhaps we can address. We should have time at the end of the presentation for questions as well. So let's start out by asking a fundamental question about who can be a notary without bond. We get calls in our office all the time saying, I want to be a notary, but I really don't want to pay for the bond. And we say, well, there's a problem with that. If you want to be a notary without bond, only certain people can do that. One statute is 406, which talks about each person to be appointed a notary public shall do these things, but then A and B do not apply to a person whose services as a notary public are performed primarily as a state officer or employee. So another statute is 653, which says that if you're a state officer or employee, you are not disqualified because a surety bond has not been purchased. So those are the two main statutes that give you statutory authority to be a notary without bond. But then the question becomes, how do you define state officers and employees? Our office has adopted an administrative rule to address that as far as you have to be an employee of a state agency. And let me just stop for a minute there and say a word about administrative rules. Administrative rules are things that state agencies can adopt. They have to put out for public comment so that the public can comment on those rules before they become official. But the fact is that once an administrative rule is adopted by an agency, it has the force and effect of law. So that means is that you have to follow that rule as well, just as you would a statute. So some people kind of think administrative rules have kind of a second-class priority, but that's really not true. And we'll be talking about administrative rules and statutes throughout this presentation. If you have not looked at them before, it would probably be a really good idea to go to our website and to look through the Notary Public Administrative Rules. There are about 11 pages of them. and they are much more specific, because oftentimes a statute may not quite be something that a notary can work with, and so we have tried to define a little bit more carefully, a little bit more stringently what the statute's about. And so if you haven't looked at the Notary Public Administrative Rules, it would probably be a good idea for you to go to our website and look at it. If you have trouble finding it, I have business cards up here. Just come get one, send me an email, and I will send you a link to those rules, and that might be the easiest way to find them. But again, this 8720 administrative rule talks about an applicant who's an officer or employee of a state agency. And then there's a section that goes further in terms of defining what kind of state agencies we're talking about. State agencies, and it's a pretty broad definition, more than you would normally think of as what a state agency might be, including courts, judicial branches, institutions of higher learning, and so forth. And then, if you want to, the easiest way to find it out if your agency is on that list is go to the comptroller's website, and it lists 930 state agencies. And you probably can't see that up there, but some things that you wouldn't normally think of as a state agency, such as the Texas Guaranteed Student Loan Corporation, Texas A&M Research Foundation, those are state agencies. And so those folks are also eligible to be a notary without bond. So now let's talk a little bit about the application that you need to file with our office. Many of you have already filed this application, and so I'm not going to go into a great detail about it. But when your commission expires in 4 years, if you want to renew it, you'll have to go back through this process. So I wanted to mention a couple of things about it. The application is found on our website. It's 2301 NB, NB standing for no bond. Whether you're applying for the first time or whether it's a renewal, it's the same application that you use. It is available. You first of all have to send it to the State Office of Risk Management, also known as SORM. They will verify that you are an estate employee, and the way they do that is they look at what the money that you send in. There are 3 forms of payment. You can send in an interagency transaction voucher, an ITV, or a state agency or university check for $11, or a state warrant for $11. So the way SORM does it, first of all, they look on the list to see if your agency is an agency that is eligible, and then they look at the form of payment to see if it's a valid form of payment. But one thing that I want to emphasize on the application is that the application is public record, and we get a lot of requests for copies of your applications. And that's all fine, except that there are things that you may not want to be public record, like your Social Security number, your date of birth, your driver's license number, and so forth. Those things are confidential at this point. That, of course, can always change. And so we have to redact that information from your application before we send it out to the requester. But your address is not confidential. And so a lot of people would prefer that especially if they're using their home address, would prefer that not be public record. Fortunately, the statute just says that you have to put down a post office address. So you can put your office address if you want to. You can even put a post office box. And so we suggest to people if they have applied and put their home address on the application, that they go in and change that. And of course, next time you fill out the application, you have the option to do it at that point too. But it is something that is public record, because The notary logbook is also public record, and one thing we'll talk about for a minute is people asking for a copy of your logbook. That's something that is public record, something people can do. And so we put your address on our website so that people know how to contact you to request a copy of your logbook. So again, if you have an address on file with us that's not the one that you want to be public record, please change it. It's easily done. Directly online you can do it, or we have forms out in the foyer here. You can pick up a form, fill it out, and hand it to one of us, and we will change it. Once SORM finishes verifying who you are and that they have the correct payment, they will send that document, that application to us, and we will go through a second verification process that's pretty quick, and then we file the application. Please do not send, if you are asking to be a notary without bond, please do not send your application directly to us, because it has to go through our 3 or 4 day mail system, and then we have to send it to SORM and go through their mail system, and it just delays things. So please send the application directly to SORM first. In addition to the application, you will also need to sign a form number 203, which informs you that the state of Texas will indemnify you for damages you sustain when acting within the course and scope of your employment, up to $100,000. The form also tells you that you're not protected if you notarize a document that's not within your course and scope of your employment. So please don't do that, and we'll talk about that again in a minute. The payment methods we've talked about. What happens if you would like to have a bond and still be a state employee? That's fine, that's up to you. If you do not want to have the restriction of only being able to notarize your office work and you want to be a regular notary, that's fine. But you just have to pay for the bond. The state agency that you work for probably will not pay for the bond, but you could pay for the bond, and then you will be a regular notary and not have the restrictions that a notary without bond has. There is a rule that says that notaries without bond who either notarize documents outside their official duties or fail to use the notary without bond seal are subject to disciplinary action by your agency, and it may also be good cause to suspend or revoke your commission. So it's pretty clear that you should not notarize outside your duties if you're going to be a notary without bond. I'm assuming that the disciplinary action that could be taken by your agency could be as even up to termination. Your seal is different. The seal that you have says notary without bond on it, so that people identify you. And what if you transfer to another agency? You may certainly do that. The notary is supposed to, the new agency, is supposed to notify SORM when that happens. If they don't, then you should, because SORM needs to keep track of where you are if you're working for another agency. You can take your notary stamp and logbook with you to the new agency. Those really belong to you, and so they're not any good to anybody else. So you can take that with you to the new agency if you wish to do so. If you terminate your employment for whatever reason, again, SORM must be notified. And then you have several options. You can either voluntarily surrender your commission. You can purchase and provide evidence to our office that you have a bond in place now to cover the duration of your commission period. Or you can surrender your notary public commission without bond and apply for a new term with a new notary bond and pay the applicable fees and so forth. So you do have several options upon termination of your employment. Your logbook. Your logbook is very, very important. We're going to talk about it some more, but keep your logbook with you. Your logbook is kind of your get-out-of-jail-free card in the sense that if you're ever questioned about a notarization that you did, if you have evidence in your logbook that the person signed it who's supposed to sign it and the other things, that's good. And so keep your logbook with you, even if you terminate your notary life, because notarizations can be questioned for years. So keep your logbook with you, and it will help you out. There is a retention period for logbooks. The records shall be kept for the longer of the term of the commission in which the notarization occurred, or 3 years following the date of notarization. So that's what the administrative rule says, so that's what the law is, how long you have to keep your logbook. But we recommend that people keep it essentially as long as you can, because just because you're not required to keep it longer than that doesn't mean that what you did 5 years ago or 6 years ago might come up in a court of law, and it would be very nice for you to have the logbook with you. The logbook, again, is yours, and even though you probably didn't pay for it, it was probably paid for by your employer, but nevertheless, it is yours, and it's a good idea to keep it as long as you can. One other idea that comes up occasionally is if you already have a commission, maybe you're already a notary with bond, what do you do when you become a state employee? You can keep that same commission. You don't have to give it up just because you become a state employee. So, and also you continue to be a notary with bond, and you don't have the restrictions that you would otherwise have. So it's a good idea to just keep that if in fact you already have the bond. Name changes. Name changes occasionally. If you go through marriage or divorce or whatever reason and you want to change your name, you don't have to do that. You can continue to notarize in the name you've been using. Most people just wait until the next time they apply for a new bond, in which case they apply in their new name. But you can continue to notarize in the name that you're commissioned under, because that was your correct name at the time, and your responsibilities and authority goes back to that commissioning that happened at the very first. So if you want to keep the same name, you can. Again, we've talked about you can do name changes online. You can also do it in forms that we have to send in. If you do a name change as a notary without bond, you don't have to go back through SORM. SORM already knows where you are and who you are, and you can just send the name change directly to us. Okay, that's all I wanted to say on that are specific to notaries without bond. Do you have any questions so far? I mean, surely somebody wants to use this cute little orange thing to ask a question. I'm told we can toss this thing, but I hesitate to. I'm just not sure. I don't feel good about tossing a microphone around.
I can't catch. Okay, what about address changes? If you move, should you change your address?
You should do that. It's very important. I'm going to talk about it in a minute, but yeah, addresses are very important. And especially if you get a complaint filed against you, and I'm going to talk about it some more, but if you get a complaint filed against you and we can't find you, that's a problem. So the address changes can be made online. We also have forms out here in the foyer for you to pick up. So please let us know where you are, because if we can't find you, that's a problem.
And I know you talked about the notaries that perform duty outside their agencies.
Mm-hmm.
That happens all too often.
Mm-hmm.
And it's not legal, right?
It is not. We have administrative rules that say you can't do that, and one of the reasons for that is the indemnity provision. Mm-hmm. The state agrees to indemnify you up to $100,000, and they don't want there to be some kind of question about that. If your neighbor comes over and says, you know, my kid needs a permission sign for me to go on this field trip, can you just notarize it? I know you're a notary. No, you just can't, because you can lose your job for that. You can be prosecuted for that. And again, it's just not worth it. There are 435,000 notaries in Texas. So surely they can find somebody else to do that for you.
And I saw on one of those stamps, it says not bonded.
Right.
On the stamp. So when they stamp the document, does that show up on there too?
Yeah, absolutely.
I mean, that's a no-brainer. Who would want that on their document?
Exactly.
I mean, I would.
No. Okay. So you get to toss it back that way.
Oh, sure.
Okay.
I think first of all, when we're talking about documents that are work related in the same aspects here, like, you know, I've had individuals come and want me to notarize ERS, like they're retired, so that's another state agency. Are we saying that we are only allowed to notarize for our individual agency or we can look for other agency forms, but not, for instance, like, if they get a ticket, you know,
Right.
you know, it's the Department of Transportation maybe, or the judicial system that they're doing to explain that?
That's a wonderful question. I wish I had a wonderful answer. Unfortunately, I don't know. If you can think of it, if you would email me that question,
Okay.
my concern is that there's probably no law on that, and that's the case of a lot of notary issues. A lot of notary issues come up that we just don't have law on. Our office, we feel like we have some expertise in this area, but we're not a court, and only the Attorney General can issue an opinion of law. But I think it's, you know, if I were the judge, I would look very carefully at what you were doing. If this was something in the normal course of your work, maybe that's covered. If it's a friend of yours who just happens to work for another agency who wants you to do this, that may be a different situation.
I would agree.
But again, if you'll think to email me, I'll talk to our brain trust and see if they have something to add that's besides that. Any other questions on any of that we've talked about so far?
What did you say the fine was for that? The fine?
There is no fine.
That's no fine.
No.
That's revocation.
It's revocation, suspension would be we could suspend you for a certain period of time. We could revoke your commission. The more serious thing to me was your agency can discipline you up to and including termination. So that would be my concern. And so it's just not something I would want to do. Yes, ma'am? I bet it's not.
Here you go.
I'm sorry?
How do you know if you're bonded or not bonded?
Okay. It will say on your commission, it will say that. If you don't know, call our office, email me, and I'll check it out. And it should also say on your stamp. Sometimes if you get a stamp from someplace that doesn't know what they're doing, they may miss that. So it's a good idea for you to email our office, because we have those records and we can tell if you are or you're not. Again, I have cards up here with my email address on it if you want to to send me an email. Any other questions on that? Well, I wanted to shift gears just a little bit to talk about notaries in general, because one of the things we do is we handle notary complaints, and we get more than we would like. And so, what I'd like to do is talk about some things that hopefully will keep you from getting on our complaint docket. The biggest complaint, the complaint that we get the most often, is that the signing party was not in your presence when you notarized the document. And just remember that you should never, ever notarize a signature when the signing party is not in your physical presence. The only exception is that we now have online notarization for certain purposes, and I'll talk about that in a minute, but that's a very, very small area of notary law. I know that we get kind of lackadaisical about it, and we occasionally find notaries who notarize for a friend or whatever, and the friend is not there, and that's this big problem. The classic case, of course, is you come in after lunch and your boss says, "My good friend Joe was here and he signed this document. So I know Joe, you know Joe, just go ahead and notarize it." And so you're thinking, do I want to keep my job or do I want to go ahead and do that? I'm sure none of your bosses would put you in that position. But in case a friend of yours asks that question, tell them, well, somebody from the Secretary of State's office made this talk a while back and they said not to do that. Let me go over to Joe's office, get him to acknowledge the document in my presence. I will acknowledge it and bring the document back. That protects Joe, it protects your boss, it protects you. Go to that little extra step if you're in that situation to make sure that you don't notarize a document when you shouldn't. Had a case recently where the notary's best friend came to the notary and said, "My husband Bill signed this, he works out of town. He said if we don't file this document today, we'll lose everything." And the notary accommodated her friend and went ahead and notarized it. Unfortunately, it was a waiver of citation in a divorce case. And sure enough, Bill did lose everything, just like she said. Bill didn't know the divorce had even been filed, didn't know that the divorce was over for 6 months after it was over. The notary is not in good shape when they do that, because not only, you don't have any defense. You don't even have Bill's signature in your logbook because he wasn't there. You can't notarize over the telephone. We have copies of letters that notaries have sent out saying to their client, "Sign this document, send it back to me, and I'll notarize it when it comes back." That's not good. The rules are all different for online notarization, and we'll talk about that in a minute. But that's the general rule, and please avoid that at all costs.
Question.
Yes, ma'am.
So
Where's the box?
next to me, I'm still talking.
Okay.
So we're saying that our rules and administrative code is different than what we just learned in the other class, which was for acknowledgments, that person doesn't have to be present for you to notarize. But we're saying here, our administrative code is saying that they do need to be present. Am I understanding that correctly?
They have to be present unless it's the new remote notarization bill.
Okay.
And that may have been what they were talking about. Under the new, Texas calls it online notarization. Some people call it remote notarization. But under that new bill, that new law, you can be in separate places. That's the only exception to that. Otherwise, the signing party has to be in your presence. The next complaint that we get most is that notaries are not providing copies of their logbook. So always, always, always provide copies of your logbook. A lot of notaries don't know that your logbook is public information. And so they get a request from somebody, send me a copy of page so-and-so on the notarization that you did on such and such a date. And they throw it away because they say it's my logbook. I'm not going to tell anybody what's in that logbook. It's mine. Unfortunately, the law says that's public record. And so if you get a request for any information in your logbook, you need to figure out how much of your logbook they want a copy of. They can ask for a single signature in your book. They can ask for a page. They can ask for every page in your logbook. They can ask for every logbook that you have. All of that is public record. And so the first thing you need to do is to count the number of pages that will respond to that request. And it's 50 cents a page. Respond back to them by letter, by email, however, and tell them that as soon as they send you the amount of money that you've asked for, you will make the copies and you will provide them those copies. But it's very clear in the law, and we get lots and lots of requests for copies of things in your logbook. If you have inadvertently included personally identifiable information in your logbook, could be some notaries write down driver's license numbers, sometimes dates of birth. We've even seen Social Security numbers. Don't do that. And if you have done that inadvertently, redact that information off of the copies. Don't change it in your logbook, because arguably that's a public record that you shouldn't change. But after you go ahead and make the copy and redact the personally identifiable information from the copy before you send it to the requester. Does that make sense? Yes, ma'am. There's the box.
So if the person, you're saying the person that that is asking for specifics in our notary book, if they request something that they just came in and had something notarized, is that correct?
I'm sorry?
It has to be specific to the person we just got through doing the notarization?
No, unfortunately.
Anybody can request anything in our book?
Anybody can request anything in your book. That's what the law says. And it seems a little counterintuitive that that's the way it would be, because especially in people that are working in some sensitive areas would not think that everything in their logbook is something that should be spread on the public record. But that's Texas law.
Okay, I work for legal in Region 8 for Health and Human Services.
Mm-hmm.
So I work with just state employees, or the majority, and attorneys. I work in the legal office. I don't have anybody that would even ask that type of, to ask for records.
Mm-hmm.
But say an attorney comes up to me and says, yes, I want copies of all the pages in there. I would have to redact all the driver's license information, all the personal information, in order to give them copies of every single page of my book?
Exactly.
That's what you're saying?
Exactly.
Really?
And so probably the best thing to do is not to put that information in your book to begin with, because that's the kind of the corollary to that. If that information could be made public, then and you're not supposed to capture personally identifiable information in your logbook to begin with.
Ooh,
So
I've done that from the beginning.
I understand. Well, that's why we're here today. Because you skip it. Absolutely.
And that's
That's required. It's not just legal. It's required. Can you throw the box over here?
Yes. I'll throw it
Maybe-
very lightly.
Maybe we can relay it. Oh, good catch. Well done.
Okay. I was told that you should put verified in that block.
That's probably good.
That's what the Secretary of State told me.
That's pretty good, because that means that, I mean, you are required to verify the identity of whoever's in front of you. And so that's what you should do, is say, I made that verification. But do not put a driver's license number, don't even put the state of Texas. The state that issued that driver's license is also confidential. So please don't put that any. And you may say, Mr. Requester, why do you want this? Doesn't matter why they want it. You can't even really ask the question, because there's no improper purpose. So again, please, we need the box back to the back.
It just says, because I know when I look at those, they detail identification of individuals, like verifying rollers, just right there.
Yeah,
Yes.
That's
Yes.
that's all you put.
Because that means that you have gone to the trouble of doing what a notary is required to do. That's one of the notary's jobs, is to verify that the person is who they say they are. That's the biggest part of the notary's job. And so put verify so that you know, so that you can say later on, I verified their information.
Okay, but I have a question, because in like divorces, in like the county case registry and the final decree, you were required to put the last 3 digits of the social, the last 3 digits of the driver's license with the state, and all of that is public record.
Well,
So that's a conflict, you see what I'm saying?
there may be individual statutes that require you to do a certain thing in your job, but certainly if someone asks you for a copy of that document, you have to redact that before you give that copy out to the requester. So you would always redact Social Security numbers, you would always redact driver's license number, dates of birth, even email addresses are confidential under state law. Back in the back here.
Is there anything wrong with saying verified by driver's license by DL?
No, that's fine, because that does not help anybody find who that person was. You can say verified by DL as long as you don't put the state that issued that driver's license.
Or it says, in their logbook, it says, is their address, does it have to list their home address, or can they list the agency as their address? Most of them put that in your paper.
The home address is not required anymore. The legislature changed that a session or two ago. The address that you put down in your book just needs to be a mailing address. It can even be a post office box. So you can put your, just so somebody can know how to get in touch with that person. So, any other questions on that?
So I have a question. All of these things that we're doing wrong now, just going forward, I mean, I know we can't tear these pages out of our book, but I think
No, don't do that. And the main thing is that you would redact that information. Them being in that book, and you're supposed to keep that book very secure. And that's another reason why you take the book with you if you go somewhere else. Good. And so it's
notary through my agency, I don't take it, I'm notary without bond, it states that. I don't take it outside the office.
good.
But when I do notarize, it is for departmental documents,
Sure.
something that the commissioner gives oath to, our examiner. I notarize those.
And again, if
the
the,
resource document.
And again, if there's a specific statute or an agency rule that requires you to do that, you probably should follow that agency or statutory rule. But before you give that information out to anyone, you would redact that confidential information. I mean, just sitting in your book, it's probably not hurting anybody, especially if you keep it locked up like you're supposed to. But if you were to give it out to someone as a copy request, just make sure that you redact that confidential information before you do that.
Yeah, this is helping me because all those things I didn't, I'm trying to you're wonderful.
Mm-hmm.
Right under, I make them sign out the whole thing.
Good.
I've been doing it for years.
Good, and we're gonna talk about that too, because everything that's in your logbook, the various categories,
Yeah.
you need to make those people fill that out, because that protects you. That's first of all what you're required to do, and secondly, if it comes up later on, you can look up, well, this person, I have their signature, I have their address, I have all this information about them, which will be in your log. It's just something that you don't want to share with anyone else. It's your book, keep it safe. Any other questions on that? Okay. And we've already talked about this. The way to keep from having to redact your log is not to write it down in your log to begin with. Do not include personally identifiable information in your book because it's causes all kinds of problems. And we've also talked about this. Your logbook has a bunch of different things that are required. The date of each instrument, the date of the notarization, the name of the signer, and so forth and so on. Go ahead and fill all that stuff out because that, again, it's for the sake of transparency. Later on, if somebody questions what you did, the more information you have, the more it will show that you did it correctly, and that if they allege that somebody else signed it, and you would have that information. So go ahead and fill it all out. There are a lot of different types of logbooks, but most of them have the main categories that are already in them. If they don't, this statute tells you what you need to put in, so go ahead and put it somewhere in that book, even if it doesn't have a column for it. Go ahead and fill out all of these things that are required. Yes, ma'am, where's the box? There it is, back there. Got a question down here.
A lot of times whenever I've notarized, it's hard to find or figure out what the date of the document is.
Yeah, it is. It is. Oftentimes, I mean, and it's not really the notary's job when they're notarizing to date the document, because there may be complications from that if you put in the wrong date. So probably the best thing to do is to send it back to the drafter and ask the drafter, the lawyer or whoever made that document, what date is the date of this instrument? Because you have delayed effective dates sometimes. You have dates that everybody has already agreed on that these other things are going to happen, so that date is important. But it's very difficult sometimes for the notary, unless the date is actually filled in, it's very difficult for a notary to know what date is appropriate, and it's really not your job because that's part of the document.
So you would reject notarizing
I would
it?
call the drafter if I could, or hand it back to the signer and say, would you call the drafter and ask them what date, or sometimes the signing party will know what the appropriate date is.
So it's not necessarily just the date you're notarizing?
No, because you don't know that. That date may trigger several other actions and responsibilities by people. So if I were, now you're going to put down the date you do the notarization, of course.
Mm-hmm.
But as far as the date of the document, that can be tricky. And I would hesitate to do that.
Is that also, can you also refer to that as the date the document was executed on? When they use that legal terminology of this document was executed on such and such date, is
Well,
that considered the document date?
Well, the statute says the date of each instrument being notarized. So to me, that means the date that everybody that's involved in that transaction agrees is the date that should be on that document. And so And again, the notary's not going to know.
And what if
so-
all the parties have not, all the parties haven't signed it?
Well, that's right. Now, you can have delayed effective dates where you can go ahead and different parties can sign on different dates. And so that can, you can do that, but that needs to be something that the drafter thought through and decided, yes, for example, the effective date is the day of the last signature. It's pretty common, if that's indeed what they want. But there may be other things going on with that transaction that you don't know about that affect the true effective date. And it's not really something that a notary has the knowledge of. Any other questions on that? Yes, ma'am.
In my book, I have a column for thumbprints.
Don't do thumbprints.
I figure, I've never had.
Good,
I'm
good.
just trying to figure out why it's in there.
Yeah.
Was that an old thing at one point?
Some states do it, and a lot of notary books are written for all 50 states. But we have a notary rule that says thumbprints and fingerprints are not appropriate. I mean, if there's one thing that's personally identifiable, it's your fingerprints. And so you do not want to put that in your logbook because, again, that's a way to identify the signer, and that's not allowed. Any other questions? Okay.
In my book, it also says type of notarization.
Yeah, and that's one of the required elements. Number 9, a brief description of the instrument. It says, well, it's two different things. The type of notarization is probably going to mean either an acknowledgement or a jurat, one of those two. Could be other things, could be a certification. So that's what that column is for. But also, there's a requirement that you describe it. Is this a deed? Is this a contract? Is this a will? That should also be in the book. So please fill that out. Any other questions? Yes, ma'am.
Could you explain number 8?
I was afraid someone was going to ask about that one. The answer is no. But send me an email, and I'll get together with the brain trust of our office. If land is conveyed or charged by the instrument, the name of the original grantee and the county where the land is located. And notice in 7 it's asked for the grantee. So theoretically, they're not asking for the same thing that you put in 7. But is the original grantee, Stephen F. Austin, if he got a land grant, in 1835? Was he the original grantee? So I wish I could help you with that, but if you'll send me an email, I'll get together with other folks and we'll see what we can come up with. It's a very good question. Anything else? Okay. I guess this is obvious, but do not practice law. Do not claim to be a notario publico unless you are one. First of all, do not practice law. We've had complaints against notaries for making out wills, deeds. They were representing party in a guardianship matter before the court. I guess it's pretty obvious that you shouldn't practice law if you're not a lawyer, but we have notaries who do that. Notario publico. Notario publico is not a Spanish version of a notary public. It seems like it should be, but Notario publico in many Latin American countries is licensed almost like a lawyer is, and they can do a lot of things that lawyers do. And so people who may, a layperson might not understand the difference between a notary public and a notario publico. If they go to one, they think it's the same thing. It's not. So please don't use that term. Do charge the correct fee for your services. Most of you probably work for the state and you don't charge a fee. You're not required to charge a fee. But know that if you do charge a fee, it needs to be the correct one. Basically, every time you use your notary stamp, it's $6. So if you have a jurat with 2 people's names on it, that's just one time that you're stamping, that's $6. The extra signature is $1. But if you have separate jurats for 2 people, that's 6 times 2. Felony convictions render people ineligible to be notaries. Our office tries to do background checks on all applications. If you've made a mistake, back in your wild and crazy youth, it might be a good idea if you can get that expunged, because records can be expunged, in which case you can say, I don't have a conviction. But that comes up occasionally because sometimes we miss it on the first application, but we catch it on the second, and people wonder why that is. Do put signing parties under oath. And you think that is kind of silly, but it is important. It's part of the notarial process. Ask them to raise their right hand, and do you solemnly swear that you are who you say you are and that you're signing this document for the purposes stated therein. And then the reason I say that is that if I'm the attorney trying to attack a will or a deed or whatever, the first thing I'm going to do is put the notary on the stand and say, did you swear in Mr. Jones? And the notary's going to say, well, yeah, I think I probably did. And you're under oath. Did you swear in Mr. Jones? And of course, the correct answer to that is, of course I did, because every single time I do a notarization, I swear in the signing party, bar none. And if you can answer it that way, then you're protected. Be sure to properly identify witnesses. The Civil Practice and Remedies Code says that you do have to require a document that is, unless it's personally known. Personally known, of course, is the way that you don't need any kind of identification, credential of any kind if you personally know the party. If you don't, the second way is to ask for a credential. Most of the time you ask for a Texas driver's license, and that works. We have a notary rule that allows, the third way has always been if the signing party brings in a credible witness. The problem is that statute says a credible witness personally known to the notary. Well, what does personally known mean? Does that mean you went to high school with them, or does it mean you met them when they came in the door 5 minutes ago? But there is an administrative rule that allows you to identify that personally known person through their credential. And so if the signing party doesn't have a credential, but they bring in someone else who will vouch for them, you can look at their credential, and that works. Mailing address, I think we've talked about, but again, it's very important that we keep a good mailing address for you. Because what happens if you get a complaint filed against you, we will send you a copy of the complaint and ask for your side of the story. But if the address we have for you is not any good, we won't get your side of the story. And so we have to take the complaint at face value. And it could end up in a revocation of your commission. And that's only the start of your problems. Because if you are no longer a notary and you don't know you're no longer a notary, you're still signing documents. Could be a will, could be a land transaction, and that could call into question that document. Because you are no longer a notary, you are no longer able to properly notarize the document. So please, if you would, go to our website when you have a chance and look up your name and address on our website and see what address we have for you. Again, if you don't like the address, if it's your personal address, your residence address, you want to put your office address, that's a good time to make that change too. Even a post office box will work. Then a couple of best practices. Do have the signing party sign your log. It is not required by Texas law that signing parties sign your log. Most people don't know that, fortunately, and they go ahead and do it because it's the best evidence that you have that the signing party did appear in front of you. And so go ahead and ask them very politely to please sign your log. Almost all logbooks have a place for the signing party signature, so that you will have proof that those folks did appear in front of you. Do not notarize a document in which you have financial or beneficial interest. I think that, again, is just common sense. There's not a statute. We have case law that says that. It's very hard to define what a financial or beneficial interest is. But again, there are 435,000 notaries in Texas, so if you think there's a question, go ahead and have somebody else do it. Always maintain your notary commission. It's your proof that you are commissioned as a notary. If you don't have it, you can go online and print out from our website a replacement. It's not going to be a duplicate original, but it is a replacement that will work. But it's good to have that in your records. Apostees, you probably don't need too much. The only thing I want to say about that is we have electronic filing in Texas, but we're not capable of aposteeing a document that. Brianna's telling me it's about 5 minutes, so I'm about through anyway. I just want to say one quick word about online notarization. There's an entire section that Brianna is going to tell us about in a little while later on online notarization. But just briefly, if you're not going to attend that session, we do have that in Texas. You can become an online notary, which allows you to notarize documents for a signing party basically anywhere in the world where there's internet access. It is a more complicated application process. It's a more expensive process because you've got to pay a bunch of money to become an online notary. But you're going to hear more and more about it over time, and so I wanted to just briefly tell you that does exist. You can notarize documents remotely if you are an online notary. That completes my presentation. If y'all want to stay around after this is over and ask specific questions, please do so. If you want one of my cards, I have it up here. We answer a lot of calls and a lot of emails, and that's our job, so we're happy to do that for you. Thank you for your time today. Appreciate it.